This lecture introduces the argument of my paper, the innovation mandate, making Europe's digital supervisory state accountable for rights, growth, and scale. The claim is not that Europe should weaken its digital rulebook. It is not an argument for deregulation, an industry veto, ministerial control of independent regulators, or an innovation defense for unlawful processing or unsafe artificial intelligence. The argument is more precise, and in my view, more difficult to avoid. Europe has built a digital supervisory state whose discretionary choices now shape the conditions under which lawful technologies can be financed, deployed, and scaled. If those choices affect rights, legal certainty, investment, and market access, they should be accompanied by a public discipline of reasons. Regulators should protect the rights floor, and they should show how they use discretion when the law gives them room to choose. The debate is usually put in terms that are too crude to be useful: rights or innovation, privacy or growth, safety or scale. That framing is analytically weak because it assumes that the European legal order must choose a single constitutional value and discard the rest. The serious question is different. Can a high rights legal order make supervisory discretion predictable, proportionate, and accountable enough for lawful innovation to be financed and deployed at scale? Weakening rights would destroy the premise of the European model, but leaving opaque discretion unaccounted for can make that model unnecessarily difficult to use in practice. The innovation mandate sits between those two errors. It asks not whether regulators should protect rights, but whether, when they have lawful discretion, they should be required to explain why the rights-preserving route they choose is necessary and no more burdensome than the law requires. The starting point is institutional. The GDPR, the AI Act, the Digital Services Act, the Digital Markets Act, the Data Act, and related instruments are not merely compliance statutes in a narrow sense. They are infrastructure for the digital economy. The GDPR determines the conditions under which personal data can be used. The AI Act will determine routes to market for high-risk systems and general-purpose AI models. The DSA and DMA structure the operating model of online platforms and digital gatekeepers. The Data Act and Data Governance Act affect whether Europe can build a functioning data economy. These instruments become economically decisive through supervisory interpretation. A regulator's approach to guidance, remedies, enforcement priorities, or timelines can decide whether a lawful product is viable, financeable, or scalable. That is why digital regulators are no longer only compliance bodies. They are market-shaping institutions in a constitutional sense. This diagram captures the key point. Enacted law does not apply itself. It passes through a discretionary layer: guidance, priorities, remedies, sandboxes, consistency work, and informal supervisory expectations. That layer is not illegitimate. In fact, it is unavoidable in fast-moving technological fields. The problem is that it is not yet disciplined by an adequate accountability structure. A regulator can issue guidance on legitimate interests, anonymization, AI training data, sandbox criteria, or automated decision-making in ways that materially affect investment and deployment, without being required to explain the economic consequences of that position or the less burdensome lawful alternatives considered. The innovation mandate targets exactly that layer. It does not alter the statutory rights floor, and it does not interfere with individual enforcement decisions. It asks for reasons where discretion of general significance becomes market condition. Discretion is sometimes treated as if it were a marginal residue after the legislature has spoken. In digital regulation, that is not true. The discretionary field is unusually thick. Under the GDPR, it appears in interpretations of legal bases, legitimate interests, necessity, special category data, anonymization, joint controllership, children's data, data protection impact assessments, certification, cooperation procedures, corrective measures, and fines. Under the AI Act, it will appear in classification, market surveillance, serious incident reporting, post-market monitoring, conformity assessment practice, regulatory sandboxes, and the relationship between standards and supervisory expectations. Under the DSA and DMA, it appears in risk assessments, audits, researcher access, recommender transparency, gatekeeper remedies, and data use restrictions. These are legal choices, but they are also investment conditions. A guidance document can be more operationally important to a product team than the abstract text of the regulation itself. The proposal can be stated in one sentence: protect the rights floor absolutely. Where union law leaves discretion, require the supervisory authority, lead supervisory authority, or the EDPB to explain why its chosen approach is proportionate, coherent, innovation-aware, and no more burdensome than the law requires. This matters because proportionality is not a decorative concept in EU public law. It is the constitutional grammar of justified public power. A measure may pursue an important public objective and still be overbroad, insufficiently reasoned, or more restrictive than necessary. The mandate, therefore, does not ask courts to maximize innovation or regulators to approve every commercially attractive technology. It asks whether the regulator identified the relevant risks, considered lawful alternatives, gave intelligible reasons, and remained within the bounds of proportionality. The legal foundation is not external to the European constitutional order. Article 3 of the Treaty on European Union speaks of balanced economic growth, a highly competitive social market economy, and scientific and technological advance. The Charter protects private life and personal data, but it also protects the freedom to conduct a business and requires limitations on rights to be lawful, necessary, and proportionate. The GDPR protects fundamental rights and the free movement of personal data. Recital 4 states, with unusual directness, that the right to data protection is not absolute, must be considered in relation to its function in society, and must be balanced against other fundamental rights in accordance with proportionality. The AI Act makes the innovation objective explicit by combining robust protection with uptake of human-centric and trustworthy AI. The mandate, therefore, makes operational what EU law already contains. The word innovation is dangerous if left vague. It can sound like a lobbying slogan, and it invites every legitimate objection. The mandate must therefore be narrow. It is not deregulation. It is not an industry veto. It is not ministerial direction. It is not a defense to breach. It does not authorize unlawful processing, unsafe AI, weaken consumer protection, or reduce protection for children and vulnerable groups. The phrase "without prejudice" is doing serious legal work. It means that the duty applies only where lawful discretion remains, and only without lowering the level of protection required by EU law. Narrowness is not a weakness in the proposal. It is what makes the proposal constitutionally credible. It tells civil society that the rights floor remains hard, regulators that independence is preserved, industry that evidence is required, and legislators that the reform can be adopted without dismantling the digital acquis. The Court of Justice's case law does not support a crude deregulatory reading. It does, however, support a mandate grounded in fair balance, necessity, proportionality, and reasoned public power. Promusicae, Shekhar, and Asnef show that open legal concepts require structured balancing rather than automatic maximal restriction. Digital Rights Ireland, Tele2, La Quadrature, and Schrems 2 show the other side of the same discipline. Where interferences are serious and safeguards are inadequate, broad appeals to security, administrative convenience, or economic interest will not suffice. Sky Österreich and Aget Iraklis confirm that business freedom is real but bounded. Meta platforms, Schufa, IAB Europe, Schrems v Meta, and KNL-TB show that data protection interpretation now directly structures platform economics, scoring markets, ad tech, advertising models, and commercial data use. The lesson is not that competitiveness wins. It is that unreasoned power loses on both sides. The economic evidence should be used with care. It does not prove that the GDPR alone caused Europe's scale-up problem, and the mandate should not depend on that overstatement. Europe's innovation difficulties are overdetermined. Capital markets, procurement, fragmentation, risk appetite, talent, industrial policy and regulatory design all matter. But the defensible inference is enough. Regulatory uncertainty, supervisory delay, and compliance friction affect the expected cost and timing of lawful deployment. Those factors matter to financing, product design, and scale. If a startup can see a demanding but clear route to compliance, it can plan for it. If the route is opaque, fragmented, or dependent on the most conservative plausible reading across several authorities, the burden will often fall hardest on smaller firms. The policy conclusion is not to weaken protection. It is to require regulators to evidence and explain the trade-offs when discretion has economic consequences.
The AI Act makes the case particularly clear because its purpose is expressly plural.
It seeks to improve the internal market, promote the uptake of human-centric and trustworthy AI, protect health, safety, and fundamental rights, and support innovation. But that architecture will depend heavily on implementation. Firms will need timely answers on classification, standards, technical documentation, conformity assessment, sandbox participation, post-market monitoring, and serious incident expectations. A regulator that waits for perfect certainty before providing practical routes to compliance is not neutral. It allocates advantage to incumbents, to better resourced firms, and to jurisdictions with faster administrative pathways. The mandate would not lower AI Act obligations. It would require the AI Office and national authorities to make implementation coherent, timely, proportionate, and innovation-aware where discretion exists. The proportionality matrix is a way of translating the mandate into supervisory method. The mandate does not ask regulators to go easy. It asks them to match the form of intervention to the rights risk and the innovation consequence, and then give reasons. Where rights or safety risk is high and innovation impact is low, strict enforcement may require relatively concise reasoning. Where both are high, the authority should provide a more detailed impact statement, explain safeguards, consider staged remedies, and publish reasons. Where rights risk is low, but innovation impact is high, the appropriate route may be fast guidance, templates, safe routes, sandboxes, or cross-regulatory coordination. The point is not leniency. The point is calibrated public administration. Different risk-impact combinations require different forms of justification and different supervisory tools. A mandate written as aspiration would achieve very little. The machinery is therefore essential. The workhorse is the supervisory impact statement, a concise public explanation accompanying major guidance, strategic enforcement positions, sandbox criteria, and other choices of general market significance. It should identify the legal uncertainty, the rights or safety risks, the likely effects on innovation and scale, the less burdensome lawful alternatives considered, the SME and startup implications, the cross-border consistency issues, and the reasons for the chosen approach. Annual KPIs should reinforce that discipline. Guidance speed, cross-border case duration, consistency, proportionality, sandbox throughput, SME support, and regulator service quality. Advisory panels can provide expertise, but only with anti-capture safeguards and no role in individual cases. The regulator keeps the decision. The mandate makes the evidence and reasons visible. The legislative program is compact. For the GDPR, Article 1 should make the regulation's dual objective operational in application, while supervisory provisions should require innovation-aware proportionality in general functions and discretionary powers. DPAs and the EDPB should publish supervisory impact statements for major guidance and strategic positions, and annual reports should address legal certainty, consistency, proportionality, and innovation impact. For the AI Act, the same duty should apply to the AI Office, national competent authorities, and market surveillance authorities in relation to guidance, sandboxes, classification, standards, and enforcement priorities. For the DSA and DMA, the immediate need is cross-regulatory coherence, because firms experience the combined effect of overlapping regimes. Germany can move first through the BDSG. The point is targeted amendment, not a general reopening of the digital acquis. Germany is strategically important because it sits at the intersection of Europe's data protection culture and Europe's industrial future. A legal culture that treats Datenschutz as the only supervisory mission will struggle to build an AI and data economy, even where the law itself contains lawful routes for responsible use. A BDSG amendment could give the BFDI and, where appropriate, the Datenschutzkonferenz a secondary duty to promote responsible data use, legal certainty, proportionate compliance, innovation, and competitiveness when exercising general functions and issuing positions of general significance. The duty would preserve the primary mandate to protect personal data and fundamental rights, exclude individual case direction, require published reasons, and create annual Bundestag accountability. An advisory panel could add technical and investment evidence, but only if balanced, transparent, and insulated from individual enforcement.
A serious innovation mandate should discipline industry as much as it disciplines regulators.
Vague claims that Europe is falling behind, that compliance is expensive, or that regulators should be pragmatic are not enough. A credible submission should identify the exact legal barrier or uncertainty the lawful activity an alternative approach would enable, the affected data subjects or groups, the rights or safety risks, the mitigation stack, the audit evidence, the expected investment or deployment consequence, and the narrower supervisory route sought. Investors and trade associations can contribute by aggregating evidence about delayed financing, abandoned deployments, duplicative compliance costs, inconsistent member state interpretations, and lost market entry opportunities. But the evidence must distinguish necessary protection from avoidable supervisory friction. The mandate should reward precision, not mood music.
The hard objections are real, but they are design constraints rather than vetoes.
The mandate would dilute rights if drafted badly, which is why it must be secondary and rights-preserving. It would compromise DPA independence if ministers, advisory panels, or industry bodies could direct cases, which is why individual complaints, investigations, fines, and corrective orders must remain outside the mandate. It could invite capture if consultation were informal and one-sided, which is why panels must be balanced, minutes and conflicts should be public, and regulators should publish reasons when they reject industry evidence. It could add bureaucracy if it applied to every operational act, which is why the trigger should be discretion of general significance. Major guidance, enforcement priorities, sandbox criteria, consistency positions, and strategic remedies. These objections do not defeat the proposal. They tell us how to draft it.
The roadmap should be staged.
In the first 6 months, the Commission, Parliament, and Council should insert GDPR and AI Act innovation duty text into the Digital Omnibus and AI Omnibus negotiations, and require supervisory impact statements for major guidance. Germany should publish a BDSG amendment creating a secondary responsible data use and innovation duty, together with advisory panel terms and annual report KPIs. In the following 6 to 12 months, the EDPB and DPAs should pilot impact statements for major guidance projects, publish SME templates, and maintain a cross-regulatory conflict log. The AI Office and national authorities should publish a sandbox learning framework and clarify classification and evidence expectations. Over 12 to 24 months, the Commission and Member States should evaluate regulator reports, identify statutory bottlenecks, and align national supervisory mandates.
The adoption of the mandate would change the behavior of each institutional actor.
Regulators would need to explain risks, alternatives, burdens, and proportionality in major discretionary choices. Industry would need to submit evidence, mitigation, investment effects, and narrower lawful routes rather than general complaints. Civil society would retain the crucial role of defending the rights floor, while also scrutinizing both permissive and restrictive supervisory positions. Legislators and courts would gain a better record for distinguishing statutory defects, supervisory opacity, and poor compliance by firms. The broader cultural change is from opaque caution or informal pragmatism to reasoned, public, rights-preserving discretion. That is the institutional contribution of the mandate. It makes Europe's digital supervisory state more predictable without making it weaker.
The conclusion is simple but demanding. Europe should not become a low-rights jurisdiction. That would be a category error, and it would abandon the constitutional premise of the European digital model. But a high-rights legal order must also make discretion accountable when that discretion shapes investment, deployment, market access, and scale. Open-ended digital regulation does not administer itself. It is interpreted, prioritized, coordinated, and operationalized by supervisory institutions. The innovation mandate is a way of constitutionalizing responsible supervisory discretion. It preserves the rights floor, makes proportionality operational, requires evidence rather than slogans, and asks regulators to give public reasons when their choices matter beyond the individual case. The demand is modest in form and significant in consequence. Protect rights, preserve independence, and make supervisors show their work.